Welcome to the deep dive. You've come to us with quite a bit of information regarding your investments in the 79th Group and, well, its associated companies.
Yeah.
And we can definitely see your concern, the confusion around missing returns and those worrying mentions of police involvement.
Understandable. It's really
completely understandable. You're looking for some clarity, and that's precisely what we're aiming to provide today. We're going to try and break down what's actually happening here.
get to the core facts, really.
Exactly.
Okay.
Separate facts from maybe misunderstandings that could actually hurt your chances of recovery.
Yeah.
And we'll outline the key actions that the information suggests you might need to think about.
And I think right off the bat, we need to address something critical we've seen in the materials. It's this belief, this idea that, oh, the police are involved, so I'll automatically get my money back.
Oh, right.
It's really, really vital. Everyone understands that's just not how it works, relying on that assumption. It could seriously damage your chances of seeing any of your investment again.
Okay, let's really dig into that then. Because the information you've shared, it makes this crucial distinction, doesn't it?
Yeah.
Between two completely separate legal tracks.
Two distinct paths, yes.
On one hand, you've got a City of London police criminal investigation that seems focused on individuals, right? People connected with the 79th Group.
Correct. Looking for potential criminal wrongdoing.
And then, completely separately, there's this civil legal process. That's for recovery, and it's being driven by a firm called Insolvency Law.
Exactly. And that process is aimed squarely at trying to get money back from the specific companies that issued the loan notes you invested in.
Right. So the difference in goals is the key takeaway here.
It's the absolute crucial difference you need to grasp. The criminal investigation, yes, it's serious. We see talk of potential arrests, prosecutions, maybe even prison.
Serious stuff.
Very. But its main goal is punishment for any crime found. It is not set up to return your investment to you. That role, the potential return of funds, falls entirely to the civil action. That's the only path being discussed here that offers a potential way for you to actually recover your money.
So if the primary goal is getting your investment back, the information is pointing very strongly towards this civil action, like the one Insolvency Law are doing. That's the only real game in town for recovery.
Pretty much, yes.
And the analysis we've seen suggests this civil route might actually be, well, faster, maybe even more likely to succeed in some ways. How does that work?
Well, it boils down to something called the standard of proof. It's quite different in criminal versus civil courts.
Okay.
In a criminal court, the prosecution has to prove guilt beyond a reasonable doubt. That's a very, very high bar.
Extremely high.
But in civil court, the standard is lower. It's based on the balance of probabilities. Basically, is it more likely than not that something happened?
Okay. So less demanding.
Much less. In a civil case for recovery like this, you don't necessarily need to prove criminal intent, beyond all doubt. Instead, you can focus on showing that, say, the information investors were given was misleading, or maybe the security promised for the investment wasn't actually properly set up.
Right. Focusing on the contract, the promises made.
Exactly. And that's often easier to establish using financial documents, agreements, that sort of thing. So this lower threshold can mean faster action and potentially a better chance of success, especially when time feels like it's ticking, which it certainly seems to be here.
And you mentioned the specific companies Insolvency Law are targeting in this civil action. Could you just list those again, just so we're clear?
Sure. The ones named are 79th Commercial 3 Ltd., 79th Luxury Living 5 Ltd., 79th Luxury Living 6 Ltd., and also 79th Resources Ltd., which is the one based out in Gibraltar.
Got it. And those specific companies, like 79th Commercial 3,
Yeah.
these are the actual entities that issued the loan notes people bought.
Yes, that's the understanding. They are key entities within the group structure, and crucially, they're the ones who directly took in the money via these loan notes.
Okay.
So by targeting them, Insolvency Law are going after the entities with the direct financial obligation to the investors, to you.
Now, something people might be wondering. Why aren't we hearing much from the police if there's this big investigation?
Yeah, that's a common question. And the information we have is pretty direct on this. Criminal investigations almost always are confidential.
Right.
They tend to take a very long time. And their main focus isn't providing updates to investors or sorting out compensation. It's building a solid case for prosecution.
So hoping for regular emails from the City of London Police about how it's going,
Right.
or thinking their work automatically gets your cash back, that's just not realistic based on this.
Unfortunately, no, it's not how the system is designed.
This is where that urgency comes in again, isn't it?
Absolutely. The danger highlighted in the information is just waiting for the police investigation to finish. Because while you're waiting, that window for civil action, the path to potentially getting your money back could be closing.
Slowly closing.
Exactly. We've also seen mentions of police warrants, raids, things like that.
Yeah, that sounds dramatic. You'd think that means progress for investors.
It's natural to think that, but the information stresses these actions show the criminal case is serious. They don't directly translate into financial recovery for you, the investor.
So a raid is about the criminal side, not necessarily your pocket.
Precisely. It shows the authorities are serious about potential crime, but it doesn't mean your funds are secured.
Okay, so the big takeaway here is waiting is passive, it's risky. Civil action can, and the suggestion is should, proceed now unless there's a specific legal block, like a restraint order.
That's the core message, yes.
Yeah.
Proactivity on the civil side seems key.
And you mentioned time ticking. Are there actual deadlines? Legal deadlines.
Yes, and this is absolutely critical. The information points to something called the Limitation Act 1980.
Okay, the Limitation Act. What does that mean for investors here?
Well, it sets a strict time limit for bringing most types of civil claims. Generally, it's 6 years.
6 years from when?
Usually, it starts from the date the harm occurred. So, in this context, likely when the investments started going wrong, when payments stopped, or maybe even earlier, depending on when you could argue someone should have reasonably noticed there were problems.
I see. And if you miss that 6-year window,
the consequences are severe. Your legal right to pursue that claim, to try and recover your money through the courts, it could be permanently lost, barred.
wow.
Which is exactly why the advice to act sooner rather than later comes through so strongly in all the materials we've looked at. Don't delay.
Okay, that's a stark warning. Now, shifting slightly, the information also paints a pretty bleak picture of the 79th Group's actual financial health right now. It's not just about them pausing interest payments, is it?
No, definitely not. The information suggests something much more worrying. Most of the group's trading companies are described as being balance sheet insolvent.
Meaning
their total debts are likely greater than the total value of their assets. Like, owing more on your mortgage and credit cards than your house and savings are worth?
not a good place to be.
Not at all. And apparently, only a handful of entities within the group show even small positive balances. Plus, and this is a big red flag, no audited accounts or proper profit and loss statements seem to have been filed recently.
So a real lack of transparency on the numbers.
A significant lack, yes. And about those paused interest payments and redemptions, while the company might blame the investigation.
Right.
The information we reviewed actually suggests that this situation itself could be seen as an indicator of insolvency under Section 123 of the Insolvency Act 1986, not just a temporary blip caused by external factors.
So the act of stopping payments itself points towards insolvency, potentially.
Potentially, yes. It raises serious questions about their underlying ability to meet their obligations.
And the scale of those obligations. The total amount tied up in these loan notes. It's huge, isn't it?
It's genuinely staggering when you see the figures laid out. For 79th Commercial 3 Ltd, it's stated as $25 million. For 79th Luxury Living 5 Ltd, $37 million.
Okay.
Then there's 79th Luxury Living 6 Ltd, a massive $500 million. And finally, 79th Resources Ltd in Gibraltar with $192 million.
So adding that up, over £500 million plus nearly 200 million euros.
Exactly. 562 million plus 192 million. Huge sums. And the critical point made in the information is the apparent lack of verified assets to actually cover these enormous liabilities.
I mean, there's just not enough stuff owned by the companies to pay everyone back.
That appears to be the major concern, yes. This massive gap strongly suggests that without investors taking proactive civil action, the likelihood of many recovering their funds is unfortunately very low.
The information also flags some concerns about specific entities and people involved. You mentioned 79th Resources Ltd in Gibraltar earlier. What was the issue there?
Well, a couple of things stood out. First, it apparently used to have different names. Luso Tesoro, Private Fund Ltd, and Castle Ventures 4 Ltd. Name changes can sometimes warrant a closer look.
Okay.
But the connection to an individual named Stephen Knight is highlighted as particularly noteworthy.
Stephen Knight, why?
Because the information links him to another company, Castle Trust and Management Services Ltd. This company acted as the security trustee for a completely different investment scheme, High Street Group.
The security trustee. What do they do again?
They're supposed to be like an independent guardian. They hold the assets backing the investment, supposedly for the benefit of the investors, making sure it's protected.
Right, with safety net.
Supposedly.
Yeah.
But in the High Street Group case, Castle Trust and Management Services Ltd. ended up in liquidation, and investors reportedly lost around $126 million.
Ouch.
So, having the same individual linked to the trustee arrangements in both situations, well, the information presents that as a concerning precedent regarding the reliability of the oversight and security.
Okay, I see the concern there. And speaking of security, the information didn't sound too positive about the actual legal document meant to provide security for one of the big ones, 79th Luxury Living 6 Ltd., the TNT debenture deed.
No, the assessment based on Insolvency Law's legal review was pretty damning, actually. It described significant weaknesses.
Such as?
Things like weak or poorly defined protections for investors. Often, a strong debenture clearly lists exactly what assets are secured, how they're valued, how they're monitored independently. This one apparently lacks that kind of specific detail.
So it's vague.
Vague seems to be the criticism, yes. Poorly defined charges over assets, no clear mechanisms for proper oversight or accountability, ambiguous language. Basically, the conclusion reported was that it doesn't provide what you'd call genuine, robust security for the investor's money.
So relying solely on that existing security might be, well, risky.
That's certainly the implication from the legal review described. It really underlines why just waiting and hoping the existing structure protects you might not be enough.
Right. Given all this,
Yeah.
The financial situation, the security concerns, the information also mentions some basic things. The 79th Group really should be telling investors, but apparently hasn't.
Absolutely. Transparency seems to be a major issue contributing to the confusion.
What should they be publishing?
At a minimum, 3 key things. First, the total verified value of all the loan notes they've issued across all these companies. Second, a detailed list, a schedule of all their assets.
Like, what do they actually own?
Exactly. And third, a clear identification of which of those assets, if any, are properly secured against specific debts and which are unsecured or free assets.
Makes sense. Without that, how can anyone judge the real situation?
Precisely. The absence of this basic fundamental information makes it incredibly hard for investors to understand where they stand and fuels the current uncertainty.
Now let's talk about the firm mentioned driving the civil action Insolvency Law. The information gives some background on them, suggests they know what they're doing.
It does provide some context, yeah. It mentions they've been operating in debt recovery for over 17 years.
So not newcomers.
No. And it gives a few examples of past work, things like achieving settlements against insurance auditors, handling group recoveries after bond collapses, getting money back for property investors and other situations.
Okay, so they have a track record in similar complex recovery cases.
The examples provided certainly suggest that, yes, experience in navigating these kinds of messy financial situations seems to be their focus.
And what specific steps has Insolvency Law actually taken in this case for the 79th Group investors? Is it just talk, or are they doing things?
No, the information indicates concrete actions have been taken. They've apparently issued what's called a formal pre-warning letter before action.
Sent to who?
To JMW Solicitors LLP, and the information is careful to point out JMW are the lawyers for the 79th Group, not for the investors.
Right, important distinction. So that letter is basically firing the starting gun for formal civil proceedings.
It's a very clear signal that formal civil recovery action is underway, yes. Beyond that, the information outlines their broader strategy.
Which involves?
Things like closely examining all the investment agreements, preparing to file claims based on potential mis-selling or breaches of contract, actively trying to trace and recover any assets they can identify.
Asset tracing.
Pushing for the liquidation of the relevant companies if necessary, and even looking at potential actions against third parties or the directors personally.
Going after directors.
That's mentioned as part of the potential strategy, yes. They also state they're ready to challenge any dodgy-looking transactions under the Insolvency Act, like assets sold too cheaply, or some creditors being unfairly paid off ahead of others.
So pretty comprehensive civil strategy then.
It certainly sounds like they're exploring multiple angles on the civil recovery front.
Okay, so let's try and pull this all together. We've covered a lot, but the main message, the one that keeps repeating in the information you shared, seems to be about time and about not just waiting for the police.
That's absolutely the core theme. That belief, the police are investigating so I'll get my money back, is presented as a harmful myth, a dangerous misconception.
Because criminal law punishes, it doesn't recover funds for victims directly.
Exactly. It might bring perpetrators to justice, which is important, but it's not designed to return your invested capital. For that potential recovery, civil action, like the process Insolvency and Law are pursuing, is described as the necessary path.
And it's a big, but only if taken within those strict legal time limits we discussed.
Precisely. That Limitation Act deadline looms large. Acting before you're potentially barred by time is absolutely critical, according to everything we've reviewed.
So if you are listening to this and you are a loan note holder with the 79th Group, the message from the information seems incredibly direct.
Yes, it really boils down to do not wait.
Do not rely on the criminal justice system alone to sort this out for you financially.
That seems to be the unavoidable conclusion from the analysis provided.
Okay. The information we've looked at today, it offers a very clear call to action, doesn't it? If you want to understand your rights, explore this civil recovery option.
You need to engage the process.
And the contact information provided for the firm leading that charge, Insolvency and Law, is investigations at insolvencyandlaw.co.uk.
That's the email address given, yes. Investigations at insolvencyandlaw.co.uk.
We'd strongly suggest, based on the information, reaching out to them immediately. Get a clear picture of your own situation and how you might protect your interests.
Definitely seems like the recommended next step. So maybe the final thought to leave people with is this. Considering everything we've unpacked today, the difference between criminal and civil paths, the shaky financials, those time limits, the action already being taken, what's the very next step you feel you need to investigate or take right now to try and safeguard your own financial future in this situation?
That really is the crucial question for every affected investor listening. What's your immediate next step?